the permission of His Excellency, the President, may I begin on a personal note. When the movement for liberation was taking place in 1971, I was a young child, as all children are, innocent, dreamy-eyed, 11 or 12 years old. I was deeply moved by the life of the father of the nation, Bangabandhu Sheikh Mujibur Rahman. I devoured the newspapers. And I was deeply distressed, even as a child, by the atrocities which were perpetrated on 200,000 women in that period of our history. I think what I learned from the story of the liberation has impacted me very greatly in my own quest for gender justice and gender equality as a judge of the High Court and now as the Supreme Court and as Chief Justice of India. In our home, every day, believe me, without exception, my father would speak about Amar Sonar Bangla and tell us what it really meant. He was trying to educate us as children in the family in his own way. Those born in Bangladesh after liberation in 1971 would now be about 53 years old, over 50 years old. It is important that we constantly remind the young generation of our societies about the sacrifices which went into the formation of this great nation. So this truly reflects the great cultural, historical, and emotional association between Bangladesh and India. But for me particularly, it's an emotional moment because as I join you in paying homage to the father of the nation, Bangabandhu Sheikh Mujibur Rahman, I go back to my own years of formation, and they have added a great amount of learning to my own existence as a human being and leading the Indian judiciary today. A testament to South Asia's collective dedication to addressing critical constitutional challenges. In an era of rapid change and evolving geopolitics, this occasion underscores the region's commitment to fostering dialogue and collaboration in navigating constitutional governance complexities. The significance of this conference cannot be overstated, especially considering the shared colonial legacies that have shaped the legal frameworks of Bangladesh, India, and other South Asian nations. Both Bangladesh and India have charted unique paths in their constitutional evolution, grappling with diverse socio-political contexts and historical challenges. Reflecting on the constitutional histories of India and Bangladesh, we recall the monumental task of establishing vibrant democracies amidst diversity. Both our countries have faced challenges, and the path to democracy is never easy. The Supreme Courts of both our nations have played pivotal roles as guardians of their constitutions, striving to create conducive conditions for human potential and development. This is essential for thriving democratic polities. It reflects on the ongoing struggle to build a rights-sensitive social system, particularly in realizing the rights of marginalized sections of our societies. The Supreme Court of Bangladesh has drawn upon various key concepts from the Indian constitutional law jurisprudence, including the rarest of rare doctrine for death penalty sentencing, the public trust doctrine in environmental law, and notably, the foundational basic structure doctrine itself. For instance, in 2015, the Taib case introduced suo motu jurisdiction, where we are not bystanders as judges, but we can take up causes if we feel that a serious injustice is done. Both the constitutions of India and Bangladesh have made explicit commitments to uplift marginalized communities, ensuring their emancipation from exploitation. equal representation in public employment, and special provisions for their advancement. Protecting constitutional rights in the digital age requires a nuanced approach, particularly in the realms of environmental constitutionalism and digital governance. Environmental constitutionalism aims to achieve environmental justice by addressing natural resource management, human health concerns, and social inequality. It empowers marginalized communities to challenge declining trends in natural resources. Limited access to legal remedies poses a barrier to transformative change. Its breadth encompasses the domestic recognition of environmental rights, which can take various forms: procedural rights, solidarity rights, directive policies or principles, adapted to the legal traditions and contexts of each country. This evolution finds resonance in the environmental jurisprudence that has emerged through public interest litigation in South Asian nations like Bangladesh, India, and Sri Lanka. In India, Article 48 of the Constitution of 1950 emphasizes the state's duty to protect and enhance the environment, providing the government significant policy discretions. Similarly, Article 18A of the Constitution of Bangladesh explicitly outlines provisions for a clean environment, being the first and only constitutional provision referencing the country's commitment to environmental protection and preservation for present and future generations. The judicial landscape has been instrumental in shaping environmental constitutionalism. In 1987, the Indian Supreme Court ruled that industries near human habitats carry public liability, mandating their relocation for environmental protection. The Sri Lankan Supreme Court's emphasis on sustainable development and adherence to international environmental obligations reflected a commitment to environmental stewardship. Recently, in a decision of 2019 of the Bangladesh Supreme Court, the Turak River case invoked the public trust doctrine and declared rivers as legal persons, imbuing them with rights and responsibilities. This innovative approach delineated a state duty to safeguard rivers from encroachment and pollution, signaling a paradigm shift in environmental governance. Privacy rights in the digital age demand heightened protection against intrusions into personal data and information. This is seen in the jurisprudential evolution epitomized by the K.S. Puttaswamy case in India. Recently, the Supreme Court of Bangladesh asserted that obtaining cell phone records without proper authorization violates the right to privacy. Safeguarding individual privacy requires robust legal frameworks and mechanisms to prevent unauthorized access and misuse of personal information, especially in the age of pervasive digital technology. The exchange of ideas between our nations extends beyond judicial principles to administrative innovations aimed at facilitating access to justice. Your judges have visited our judicial academies, and we look forward to our continued collaboration where Indian judges and district judges will come and visit Bangladesh. The preservation of constitutional rights in the digital age necessitates proactive measures to address emerging challenges and uphold fundamental principles of justice, equality, and human dignity. By fostering a culture of cross-border collaboration and learning, we can navigate the complexities of the digital era while safeguarding the rights and freedoms of our individual citizens. As we convened today and tomorrow to examine lessons from Bangladesh and India, we embark on a journey of introspection and learning, drawing from the experiences, successes, and challenges encountered in the development of constitutional courts. Through scholarly discourse and exchange, may this conference serve as a catalyst for deeper understanding, collaboration, and the advancement of constitutional governance in South Asia and beyond. The visit of the Chief Justice of Bangladesh to India In fact, the visits of the Chief Justice of Bangladesh to India have cemented the close relationship between our constitutional systems. We are going to enter into a life of contradictions. In politics, we shall have equality, and in social and economic life, we shall have inequality. We must remove these contradictions at the earliest possible time. These words resonate with the ongoing struggle for equality and justice, urging us as judges, as lawyers, as academics, and as citizens to work tirelessly to a more just and equitable society for our nations. Thank you for inviting me.